Let's talk about more pleadings and more discovery. All right, this is great. This will probably be the sequel to the Federal Pleadings TV show. Let's talk about case management orders and discovery techniques. What that means. Lone Pine was the name of a case in New Jersey back in the 1980s. And it's kind of a bellwether case, because what the courts did then was a little bit unusual for the times, and it was unusually got granted. What they did was they allowed the establishment of a framework or a case management approach that required the plaintiffs to make virtually a prima facie case on causation for the claims that they were putting forward before any further discovery went forward as to what defendants might actually have been involved, what damages might actually be suffered by the plaintiffs, what the amount of those damages were, all those kind of other things that might happen in the regular course of a lawsuit, and that the plaintiffs would have to prove eventually. The courts pushed up or moved up the requirement of establishing that they had credible expert evidence that was going to support the plaintiff's theory of liability. So, Lone Pine order, what is it? Why to have it? Who needs it? So, what is it? Well, we just talked about. It's a tool for managing the litigation. It's a tool for the courts to use to craft both limitations on discovery, focus on discovery, scope of discovery early on, to find out how the parties can most efficiently and effectively get to the evidence that will need to be presented by the plaintiffs to establish whatever issue the court decides they want to establish. In the Lone Pine case itself, it was a causation issue, can be other issues, but the idea is the claim comes in, the complaint is voluminous, extensive, all kinds of damages, all kinds of issues raised, all types of a dozen causes of action set forth. How is the court going to manage that and let that happen? If the court is kind of passive in that, then what's going to happen is the parties are going to go in 12 different directions, motions, fighting, fussing, and it takes a lot of the court's time to actually manage and structure that. So what the Lone Pine order is designed to do, why have it, allows the parties to prove and or challenge the plaintiff's theories of causation or liability theories without having to get into damages discovery. If you've got a massive tort claim where it might be a dozen plaintiffs, or you've got 120 plaintiffs, or you've got a case like we've got where we have over 400 plaintiffs doing the medical discovery, the damages discovery of all those plaintiffs is tremendous. It's almost hard to sit down and calculate out what all it would take in terms of document production, hours of work by paralegals, lawyers, litigation support folks, and on and on and on. So what this does is allows us to get focused on that. Who's going to need this? Who wants to do it? And frankly, it's primarily the defendants that are pursuing this. They're seeking to address what the needs are of their individual defendants, so they can either weed out particular causes of action that are not really going to apply. You find sometimes you get in these discovery battles where somebody has pled a cause of action. It's a little bit on the edge of what might be provable, and the plaintiff wants to engage a lot of discovery of the defendant, maybe in a way that causes the defendant a lot of expense or harassment or embarrassment. Well, the Lone Pine order or a case management order like a Lone Pine order can make the plaintiffs, put the burden of the plaintiffs to have to prove that that cause of action is going to survive, that there is some reasonable foundation for that, rather than to give plaintiff a chance for a fishing expedition into discovery about unfair trade practices or something, when really the case is not really but a simple contract dispute. So this will help kind of narrow down the field, weed out the weak. So, doing it this way, what is it going to take from the defense side? What does it take from the insurance carrier side? Well, it's going to take more work up front. It takes more focus on the claim up front. It takes more planning up front. And all that yields what we know, more cost up front. But without spending that, it's just delaying and deferring the cost and probably putting it in a much more expensive posture. So for the right cases, the right claims, the right problems at hand, this kind of an approach is really, really effective. Plaintiffs, lawyers, and other commenters will say that this is a burden shifting, that's unfair, that our court system doesn't support this, that it puts the burden on the plaintiff for proving their case first before they get to do any discovery of the defendant to find out what all the bad stuff the defendant has done before they get to go find out the smoking gun, etc. And there's some validity to that, or else the argument wouldn't be made. But the real question is what's the most effective means for dispute resolution? What's the most effective means for the court systems and for the cost of the court systems? Just like other elements of government, the court systems are becoming increasingly time sensitive and cost sensitive. In a state like South Carolina, we have probably twice the number of cases in our general trial courts per judge, twice the number of cases, and unfortunately I don't have a great definition for this to put up. We have twice the number of cases per judge than most other states do. So our state court judges are shepherding twice the volume just by head count, just by number of cases filed, as state court judges in many other states are. In some states, the ratio is like 7 or 8 to 1. So some of our judges are just tremendously burdened. And if they've got a well-planned, well-thought-out, well-reasoned case management, lone pine order, motion put forward, then there's a chance that that's going to make sense to them. There's a better chance that the more often they see this, that they think about this, they consider it, that they'll start to see the value of it, and that we'll be able to get some of these cases more focused, more expedited, and handled more efficiently and cost effectively. So the more the judges see them, the more they're going to be accustomed to granting them.